How are you stuck right now? Seriously, think about it. Are you desperately trying to avoid some massive, drawn-out court battle? Maybe you're trying to break a stubborn deadlock with a partner, or, just trying to keep a firm grip on your company's future. Look, if you're a startup founder, you already know that business conflicts, they happen. It's inevitable. But here's the thing. They absolutely do not have to break your company.
Welcome to This Explainer. Today, we're diving straight into cost-effective dispute resolution for Lenexa startups, and we're drawing some really fascinating insights from Bose Mediation. Over the next few minutes, we're going to unpack exactly how small and medium enterprises can tackle serious business conflicts without, completely destroying their company, losing their sanity, or entirely draining their bank account.
Okay, let's dive into this. Here is our roadmap for today. We'll be covering 5 key areas. 1. The cost of business conflict. 2. 3 distinct resolution methods. 3. How to actually choose the right approach. 4. The power of mediation. And finally, 5. How the process works.
Section 1. The cost of business conflict.
Now, as a startup founder or small business owner, I really want to validate your fears right out of the gate here. Dealing with business fights, it is going to chew through a massive amount of your most precious resources, your time, and obviously your money. The stakes are literally sky high when things go south. So this brings us to a really critical comparison. On one side, you've got litigation. That's the traditional route, right? Dragging things into a courtroom. It's notoriously slow, incredibly expensive, and let's be honest, it has a nasty habit of destroying whatever working relationship you might have left with the other party. But on the flip side, we have alternative dispute resolution, or ADR for short. ADR gives you choices that are vastly cheaper, super flexible, and honestly, they're designed to actually protect your capital. It's no wonder a huge number of U.S. companies are totally ditching the courtroom and pivoting to ADR to handle their messes.
Moving on to Section 2. 3 dispute resolution methods.
So, once you decide to step away from that courtroom, you generally have 3 distinct options. And what's really interesting here is how they differ based on who's in the room and, well, who holds the ultimate power. First up is negotiation. This is the most informal method. It's literally just you and the other party hashing it out. Zero third-party involvement, just working together to reach a mutual agreement. Then, stepping it up a bit, there's mediation. Here you bring in a neutral third-party facilitator. Now, they don't make the decision for you. Rather, they're there to help both sides communicate smoothly so you can mutually agree on an outcome yourselves. And finally, arbitration. You still have a neutral third party, but in this case, they act as a formal decision maker. The outcome? It's a binding decision imposed entirely by that arbitrator.
Let's actually clarify that last one for a second, because arbitration often gets completely confused with litigation. Simply put, arbitration is a formal alternative to going to court. A neutral third-party arbitrator sits down, listens to the proof from both sides, and then makes a final, binding decision. And yes, everyone absolutely must follow it. You can think of it kind of like a mini-trial. But the key difference? It's usually a whole lot quicker, it costs less, and importantly, the rules of evidence are often way looser and much more open than what you deal with in a strict courtroom setting.
All right, Section 3. Choosing the right approach.
So knowing your methods is great, but how do you logically evaluate your own specific business conflict to pick the absolute best path? The crucial point is you really have to systematically weigh these 4 distinct elements. First off, complexity. Just how tangled is this problem? Really simple issues might just need a quick, direct negotiation. But a highly complex, technical issue, that almost demands bringing in an expert arbitrator. Second is relationship. For instance, say this is a key software vendor you absolutely need to keep working with to keep your app online. In that case, mediation is going to be far better for you than arbitration. Third, cost. Put simply, exactly how much capital are you willing to burn to solve this? And fourth, confidentiality. Do you need this whole mess kept strictly off the public record? If you run your conflict through this 4-part framework, I promise you, your path forward is going to become completely clear.
Section 4. The power of mediation. Now, when business owners run through that framework, they very often land on what I like to call the Goldilocks choice, mediation. It really is the ultimate tool for preserving both your business relationships and your hard-earned capital. Let's just rapid-fire some of these key advantages, okay? First, it's incredibly cost-effective compared to litigation. Second, it offers serious speed. You're resolving problems much, much faster. Third, confidentiality is built right in. Fourth, you retain total control over the outcome, rather than, crossing your fingers and handing your company's fate over to a judge. And finally, and maybe most crucially, it really allows for relationship preservation. Because a mediator keeps everyone focused entirely on solving the problem together, instead of just pointing fingers and assigning blame, a lot of businesses find they can easily keep working together even after the mediation wraps up.
And I really want to emphasize that point about confidentiality. It is an absolute lifeline for small and medium enterprises. Literally everything you share in mediation stays completely private and entirely off the public record. Think about it. When you go to court, your disputes, your internal financials, your trade secrets, they all risk becoming public knowledge. By avoiding those public court dockets through mediation, your company's name and your highly sensitive business details are kept completely under wraps.
Let's move to Section 5 and see how this builds, how the process works.
Let's completely demystify what actually happens when you step inside a mediation room. The process flow is wonderfully simple and it keeps you totally in the driver's seat. Step 1. All parties agree to mediate, and you pick a neutral mediator. And remember, they absolutely do not take sides. Step 2. You sit down and discuss the issues in good faith. And here's a really great part of this. The mediator can bring everyone together in one room, or if things are tense, they can put you in separate rooms for private sessions. This lets you freely share your worries and your bottom line without the other side listening in. Step 3. You reach a mutual agreement and you write it down, which usually turns into a legally binding contract. But wait, here is the absolute best safety net. If you guys don't reach an agreement, you literally haven't lost anything. You can still go pursue arbitration or litigation right afterward. It's basically a zero-risk environment for problem solving.
Before we wrap up today, I want to address a very specific and frankly highly emotionally charged question that comes straight from our source material. Can dispute resolution actually be used for family-related business conflicts? It's a huge question because family businesses carry these incredibly complex, deeply personal dynamics that standard businesses simply don't ever have to navigate.
Well, the answer is a resounding yes. In fact, I'd argue mediation is the absolutely perfect fit here. It offers this private, safe space to protect both the financial business structure and your delicate family ties. Because the whole mediation framework insists that everyone speaks and acts in good faith, you can safely solve these deep-rooted problems without the toxic, inherently adversarial nature of litigation, because let's face it, a courtroom is, by definition, designed to pit people against each other.
Which brings us to a final, pretty provocative thought for you to walk away with today. Ask yourself, will you let business conflicts silently drain your startup's resources, or are you going to take control and resolve it effectively? The choice between bleeding your time and money out in a courtroom or actively preserving your capital through ADR methods, it's entirely up to you. Thank you so much for joining me for this explainer. Keep learning, keep taking control, and I really hope this empowers you to handle your next big challenge with absolute confidence.